Hello and welcome. My name is Alan. This was meant to be Monday's video for notable names in Asian American history. Uh, but essentially, this deals with a uh, court case in U.S. history that deals with the Equal Rights Clause in the 14th Amendment, which is something that's very connectable to modern day because with the way the Trump administration has gone after immigrants, yeah, they're very much violating these clauses and everything else. But let's get into this here. First, let's look at this case from I don't know why it rolled me so far down. There we go. The case is Yick versus Hopkins. May the 10th, 1886, Lee Yick won a Supreme Court case that ensured that all people, citizens and non-citizens, had equal protection under the law. Which again, that's being violated. Even though it was confirmed in the 1880s. Yeah. They had protections. But anyway, Lee Yick and Lee, Chinese immigrants, ran laundries in San Francisco. In 1880, San Francisco passed a law requiring a permit for laundries housed in wooden buildings as they were more vulnerable to fires. Of the 320 laundries in San Francisco, 310 were in wooden buildings, and most of them, 240, were owned by Chinese persons. Only 10 laundries in all of San Francisco were not in wooden buildings. The rest of them were, and of those, only 70 were not owned by Chinese persons. Not one Chinese laundry applicant was issued a permit. Not a single owner of the Chinese laundries were given a permit. But San Francisco had just passed a law that any laundries in wooden buildings would require a permit. You can see where the violations are going. When Sheriff Hopkins tried to arrest Yick and Lee for not having a permit, they refused to pay the $10 fine and were jailed. Each sued, arguing that the fine and discriminatory enforcement of the ordinance violated their rights under the Equal Protection Clause of the 14th Amendment. Their cases, compiled under the name Yick versus Hopkins, was argued at the Supreme Court in 1886. Yick was the name of the laundry that Lee Yick ran. In a unanimous opinion authored by Justice T. Stanley Matthews, the court concluded that despite the impartial wording of the law, its biased enforcement violated the Equal Protection Clause. According to the court, even if the law is impartial on its face, if it is applied and administered by public authority with an evil eye and an unequal hand, the kind of biased enforcement experienced by the plaintiffs, the court concluded, amounted to a practical denial by the state of that equal protection of the law and therefore violated the provision of the 14th Amendment. So yeah, essentially, while the law itself seemed to be okay, it was the way it was enforced. And thus, it made it unlawful. Because if you're not ensuring that everybody can have a permit, citizens, non-citizens, as long as they have a business and they've applied, they should be given their permit. And that's the argument here. To go a little further, a lot of the big problem was the racism of the era against Chinese. You had the Chinese Exclusion Act of 1882. And it prohibited all immigration of Chinese laborers for 10 years, 1882 to 1892. The law made exceptions for travelers and diplomats and also denied Chinese residents already in the U.S. the ability to become citizens. And Chinese people traveling in or out of the country were required to carry a certificate identifying their status or risk deportation. This racist streak has always underlaid the U.S. A lot of people may not want to admit it, but you just review history and it becomes clear as a bell. But yeah, there would be other Chinese exclusion laws. I think there was one in 1886 as well. I can't remember exactly. I know we talked about it a bit with some of the other Asian individuals whom we did the done videos on, but yeah, the Exclusion Repeal Act in 1943 during World War II when we were fighting the Japanese. Yeah. Would be when we actually change it. Other than that, enforced for 60 years. Yeah. (1886) advertisement for magic washer detergent. The Chinese must go. So it was a detergent company saying, yeah, kick the Chinese out. I mean, that's how intrinsic some of the racism has been in U.S. history. Yeah. Anyway, it just shows how embedded racism against the Chinese were in the U.S. and why many of these permits wouldn't be allowed to them, even though so many Chinese owned the actual laundries. But the Equal Protection Clause refers to an idea of the government that a governmental body may not deny people equal protection of its governing laws. The governing body state must treat an individual in the same manner as others in similar conditions and circumstances. It is important to acknowledge that a government is allowed to discriminate against individuals as long as the discrimination satisfies the equal protection analysis outlined below. So, yeah. Equal protection means that the immigrants that the Trump administration is just kidnapping off the street and sending to El Salvador is a clear and evident violation of the 14th Amendment Equal Protection Clause. The Fifth Amendment's Due Process Clause requires the United States government to practice equal protection. The 14th Amendment's Equal Protection Clause requires states to practice equal protection. Equal protection forces a state to govern impartially, not draw distinctions between individuals solely on differences that are irrelevant to a legitimate governmental objective. Thus, the Equal Protection Clause is crucial to the protection of civil rights. So, yeah. When an individual believes that either the federal government or a state government has violated their guaranteed equal rights, that individual is able to bring a lawsuit against that governmental body for relief. Or they used to be able to until Trump's bullshit. Based on the type of discrimination alleged, the individual will first need to prove that the governing body actually discriminated against the individual. The individual will need to prove that the governing body's action resulted in actual harm to them. Yep. Taking Hispanic individuals, the majority of whom have no criminal record, no evidence of criminal records, of evidence of criminality. It's just because they were Hispanic, Latino men. They were rounded up and sent away. That is clear discrimination. After proving this, the court will typically scrutinize the governmental action in one of several three ways to determine whether the governmental body's action is permissible. These three methods are referred to as strict scrutiny, intermediate scrutiny, and rational basis scrutiny. The court will determine which scrutiny the individual will be subject to, relying on legal precedent to determine which level of scrutiny to use. It is important to note that courts have combined elements of two of the three tests to create an ad hoc test. Further reading, blah, blah, blah. Now, from constitution.congress.gov. Okay. The 14th Amendment, equal protection and other rights. We've already read this once, but clearly I want to make sure it is driven into people's minds. All persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Yeah. So it's saying essentially, hey, look, they've got as much protection. You know, it doesn't matter if you arrived in the U.S. or were born. You are subject to the jurisdiction thereof, and while here are considered citizens. So yeah, and we've got the Wikipedia article on it pulled up as well. But anyway, let's look at this further. This is from Oye. Facts of the case: an 1880 ordinance of the city of San Francisco required all laundries in wooden buildings to hold a permit issued by the city's Board of Supervisors. The board had total discretion over who would be issued a permit. Although workers of Chinese descent operated 89% of the city's laundry businesses, not a single Chinese owner was granted a permit. Yick Wo and Wo Lee, which operated laundry businesses without a permit, and after refusing to pay a $10 fine, were imprisoned by the city's sheriff, Peter Hopkins. Each sued for the writ of habeas corpus, arguing the fine and discriminatory enforcement of the ordinance violated their rights under the Equal Protection Clause of the 14th Amendment, noting that on its face the law is non-discriminatory. The Supreme Court of California and the Circuit Court of the United States for the District of California denied the claims for Yick Wo and Wo Lee, respectively. The question becomes, did the unequal enforcement of the city ordinance violate Yick Wo and Wo Lee's rights under the Equal Protection Clause of the 14th Amendment? Conclusion: yes. In a unanimous opinion authored by Justice T. Stanley Matthews, the court concluded that despite the impartial wording of the law, its biased enforcement violated the Equal Protection Clause. According to the court, even if the law is impartial on its face, if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances, material to their rights, the denial of equal justice is still within the prohibition of the Constitution. The kind of biased enforcement experienced by the plaintiffs, the court concluded, amounted to a practical denial by the state of that equal protection of the law and therefore violated the provision of the 14th Amendment. So yeah. While the law in and of itself was not discriminatory, the way it was applied was very discriminatory. We have the Wikipedia article on it. Yick Wo was a laundry facility owned by Lee Yick, an immigrant from China who moved to San Francisco in 1861. Yick ran the laundry for 22 years and held a license from the Board of Fire Wardens and a certificate of inspection from the city health officer without issue. In 1880, the San Francisco Board of Supervisors passed an ordinance making it illegal to operate a laundry in a wooden building without a permit from the board. Under the new ordinance, Yick was granted a license in 1884 to operate his laundry facility in the wooden building where he was located. Yick's application for renewal of his permit in June of 1885 was denied, not allowing him to continue operating his laundry in a wooden building. When his original permit expired in October of 1885, he was required by law to shut down. However, he refused to close down his business and was convicted for violating the ordinance. He was fined $10, $326 in 2024, and imprisoned for refusing to pay the fine. After he was imprisoned on August 24th, 1885, he petitioned the California Supreme Court for a writ of habeas corpus. I think they got some dates wrong here. August 24th, October. They're both 1885. Of 320 laundries operated in wooden buildings in San Francisco at the time, over 200 were owned by Chinese. When the 200 Chinese-owned laundry owners tried to renew their permits, only one permit was granted, whereas the non-Chinese applicants, with the exception of one, all were granted. So we have what amounts to clearly a racist application in the way permits were handed out, and thus a racist application of the ordinance. We've got them talking about the ordinance, what each section said. The central issue of the case was whether the enforcement of the new requirements for laundries operated in wooden buildings violated Yick Wo's protections found in the U.S. Constitution. The Equal Protection Clause can be found in the 14th Amendment of the U.S. Constitution and requires that no state deny any person within its jurisdiction the equal protection of the laws. There is also the issue around whether a law can be written in a neutral way but enforced discriminately. The way it was argued, how the opinions were written. As Justice Anthony Kennedy has explained, the holding of Yick Wo is about purposeful discrimination. The holding of Yick Wo was that a law that's administered with an evil eye or an unequal hand violates a person's right to equal protection. The legacy of it. And how it's applied to other similar cases. In San Francisco, there is a public school named Yick Wo Alternative Elementary School in honor of Yick Wo. During his confirmation hearing, Anthony Kennedy's written answers to then Senator Joe Biden included a quote from Flores v. Pierce, a 9th century decision he wrote applying Yick Wo to uphold the judgment against municipal officials who had a history of racially motivated activity against Hispanics. One of the first cases interpreting the Equal Protection Clause stands for the rule, among others, that the effect of a law may be so harsh or adverse in its weight against a particular race that an intent to discriminate is not only a permissible inference, but also a necessary one. Yick versus Hopkins. In the instant case, the disparate effect of the action on Mexican Americans was so compelling that the effect may approach, if it does not reach, the demonstration of an intent to discriminate that was made in Yick versus Hopkins. So yeah, referring essentially that there have been cases that, although not necessarily aimed at Latin Americans, have been enforced discriminately against Mexican Americans. So yeah. Now, from APIA biography, Yick is the name of a laundry owner, or laundry owned by Lee Yick, located on 349 3rd Street in San Francisco. Lee Yick left a farming area in Canton to immigrate to the U.S. in 1861. Not Canton, Ohio, where we're talking a region in China. He owned his business in 1863, or opened it, and ran it for 22 years. The Board of Fire Wardens and Health Department approved Yick Laundry to be safe and satisfactory in 1884. However, August 22nd, 1885, Lee Yick was jailed for refusing to pay the $10 fine for operating without a license. The case went to the Supreme Court, which ruled on May the 10th. Again, they got 1885. There's a lot of miswritten dates. See, because here it's 1886, but 1885 here, so it's probably meant to be May 10th, 1886. That the San Francisco law was prejudicial against the Chinese and an infringement of the Equal Protection Clause in the 14th Amendment of the Constitution. So yeah. Not a lot on actual Lee Yick, but we see the reason he's been so important when in Asian American history. It's a law that deals explicitly with discrimination, more or less in a racist way, because we know, of course, there's multiple forms of discrimination, but it was racist discrimination against Chinese immigrants, or just Chinese in general. So yeah. But we'll go ahead and end this episode there. As always, educate thyself. Think, read, study, learn. Someone tells you something you have trouble believing, ask them to cite their sources. I'll be putting these links and sources in the description box below the video. Thank you all for watching. I'll see you all in the next one. Until then, later.